Good morning. I'm Melissa Schwartz, and I'm the managing broker of the Realty One Group Paradise Valley office. Could you do me a favor and get what just printed out there for me? We were not able to get our our Facebook group going, but we are going to share my screen and get you plenty of data today. This is going to be very fast paced. Thank you. Where'd my share this and go to our presentation. All right. Oops. I'm going to go to a slideshow mode. If anybody online has questions, they're gonna have to, oops, did not mean to do that. I was trying to move my screen. I don't know if I can go back. Okay. So we are going to go over the top 15 contract processing issues. I want to give a special thanks to Cherie Allen. If you've ever loaded a document into SkySlope, she has seen your documents. So she is an associate broker with Realty One Group, and she is the Paradise Valley Compliance Document Reviewer. No, folks, I don't stay up till 4 in the morning every day to look at your documents. I only get the ones that she puts a little red flag on and says broker review. So we are going to fly through here. I got from her more than 10 of these, but I had thrown in a couple of my own. A couple I am not doing today. We've already had classes on, and I decided I'm not going to even flip through those because we have a whole class about them. So I'll mention those later, but let's start with the number one issue on contracting, contract files that we get that is a problem. Anybody have a guess? Anybody have a guess on what document might be impacted by that the most? All right. The READY form. So everybody knows it as the READY form, Real Estate Agency Disclosure and Election. That is our agency form. And the issue that comes up is checking the correct boxes. What happens is people do put this in, but they don't know which box to check. And we're going to talk just real quickly because this is going to actually be the number one and the number two issues we have this morning. The first is which box to check and why. So let's take a look at if you represent a buyer. Can you do this? Can you do that? Can you have all three of those boxes checked? No? Seller, buyer? No? You can't check all three? You'd be surprised. People check all three. So I don't know. I don't know if you're not reading your documents, but you cannot check all three because you cannot represent both the buyer as the buyer's broker and the seller as the seller's broker. What is that called? It's called dual agency. And we'll get to that a little bit later. It's the third one we're going to deal with. But for starters, what you need to do is if you represent the buyer, check boxes, box 48 and 50. Now, why should you check box 50? Oh, everybody's quiet this morning. Okay, we're going to have to pick the pace up here.
Because they do your agency? No.
Limited representation. Limited representation. But let me ask you this. Can you show a Realty One Group property if this box is not checked on your agency and you have a buyer? If you see a sign that says Realty One Group, can you enter that property with that buyer?
I'm going to say no. I don't know.
It says show buyer properties listed with a broker's firm. So if they have not told you that you can show Realty One Group properties, guess what? You can't show them. You need to have that conversation before you take people out on the road, right? If you represent them as a buyer, if you're not talking about limited representation and talking about dual representation, right? That you might be on both sides, or gosh, the company might be on both sides. What happens if you walk into that home and they say, what do you think about the price? What can you say? What can you say? Well, but even if you haven't checked the box, what can you say if that is a Realty One Group property?
If they ask what, but
If they ask, what do you think about the price?
That's
Walked
the
into the-
price. That's the
What?
price. That's the price.
That's the price. Cause why?
because you're,
Because you can't have an opinion because you're not actually, it's limited representation.
That it is limited representation. So if you've not talked to your client before you go out about what limited representation or dual representation means, well, you're going and showing a property, they start asking you questions and you're like, I can't tell you. I can't tell you. I can't comment. What do they think? What do you think they're going to think about you? Like, if you haven't talked about this, this needs to be a part of your conversation. And the first document you do with your client should be this ready form, right? And it should address about possibly showing Realty One Group agents. We have 3,000 agents in the Maricopa County area. That's a lot of agents. And there are a lot of listings. Last I checked, there were over 900 listings in this area. You're not going to show any of them? Really? How many of you in this room have shown Realty One Group property listings with a buyer? Yeah? Online? Thumbs up? Yes?
Absolutely.
Yes. Yes.
Okay.
Yes.
All right. So
Yes.
if you're a buyer and you're doing the a buyer's agent ready form, you got to do that with them. Whoops, where'd I go here? All right, let's keep going. Seller. Look, I moved boxes. We're not representing the buyer as buyer's broker. We've moved down to 56 and 57 because those two tie together. You represent the seller and you are then allowing the seller's property to be shown by buyers represented by the broker's firm. If in fact you are not checking that box, if an agent contacts you to show from Realty One Group, are you going to say, yeah, go ahead and show? Technically, no. Right? Again, you have to have that conversation with your seller. Do they want limited representation? Are they okay with dual representation? If that conversation is not happening before you do this, what happens when an agent comes in from Realty One Group and sends that offer over? Technically, are you really allowed to show that offer? I mean, you have to, but you better go back to your agency form and add this checkbox because you've missed a whole section of your communication. This is the main thing that needs to be addressed. Now, I put this in here because Cherie said this is the #1 error is the boxes that are checked. I'm taking a different tact as the broker. If these boxes aren't being checked, it's because you guys aren't doing your job. You need to know how important it is to show your representation. We talk about we're supposed to be able to show our value. This is #1 on your value is understanding limited representation and how to explain that to your clients, whether it's a buyer or a seller. So, and this was not included because this is brand new on the form, but on the top of, whoops, and I'm in the way here. Let's see if I can move me out of the way. Hey guys I'm going to take your photos off because we can't see here. Sorry about that. I just have mine on there so I can see whether I'm moving around or stuff. So, I'm expecting this will rise quickly to the top 10 is missing the initials on line 45. For those that have not looked at a ready form recently, this is the brand new ready form. And they've added a paragraph that says agency election does not establish broker compensation. Who initials on line 45? Buyer or seller, doesn't matter which. If they're your client and they're signing this document, they have to initial. Every single client that signs a ready form, they have to initial on line 45, or guess what? This document is coming back to you with a note saying, go get initials. Okay. Again, this is part of what you're supposed to be explaining to your client. So that should not be missed. Now, ironically, #2 is contract processing issue is an unrepresented party, buyer, tenant, or seller. Now, I've split those up. Buyer or tenant, you're doing the same exact thing, just on a different form with the ready form. So let's look at the buyer tenant version. There are 2 different steps. I covered this the other day, so I'm going to go through this really quickly. First, you have to prepare the ready form. That's the agency form if you're not following along. And just going away. Okay. Okay, so real estate agency disclosure and election. Now, I have filled in my information at the top of this. When you are working with an unrepresented buyer or tenant, you still fill out the top of the ready form. What you do next on the next page is you check box 49. You are representing the seller as the seller's broker or the landlord as the landlord's broker, okay? And on the bottom, the undersigned on line 60 is saying buyer or tenant, right? Same. You have to do this first, and then does anybody remember what I told folks to do the other day in my class? What do you do now? Anybody remember? Oops, save that. Whoops, I don't know why that didn't say that, but that's okay. So you need to actually print that to a PDF, okay? Because you have to lock that down. That works in tandem with this form here. Look what happened when I put that stuff in there on the top of the purchase contract, or yes, the lease, it's going to drop in under the buyer broker. It's going to drop my name and my company and the checkbox for the seller on the bottom. Is that what you want for an unrepresented buyer? Our title person's going, no, it's not. She doesn't even write our contracts. You're correct, it's not. Because you need to change this to say unrepresented with no boxes checked on line 450. All right. But the problem is those documents work together. So when you fill out one, it auto-fills that other form. So when you do your agency, you do it first, print it to a PDF, save that document so you can add it to your signatures, but save it to the side. Okay. Then go into your purchase contract or lease, fill this stuff in, go in there, make sure you've done both the unrepresented and then on line 450, removing any check boxes. Now let's see if I think I went over to unrepresented seller. So there you need the agency for the seller, an unrepresented seller compensation consent, and then a purchase contract. Why do we need that middle one? If you represent the buyer and the seller is unrepresented, why do we need unrepresented seller compensation consent?
You won't otherwise. You can get your commission.
You won't get paid. When do you present that to the seller? When do you present that consent form to the seller?
Prior to making the offer.
Prior to making the offer. Very, very important. Prior to making the offer. Because guess what? If the offer and they don't like the offer, guess what's happening, you know, to that document that you didn't give them? They're not going to sign it, right? You want to negotiate with them what you're going to get as the unrepresented seller, what they're going to pay you as a buyer's agent, right? Before you give them that offer. Now, is it negotiable after that? Yes, but if they've agreed to pay you something, they have to keep that in mind with whatever that offer is, right? So here we're going to start with the agency again. You start with the agency the same way, firm name, the firm, and then your name. And then the seller section down on the bottom says, oh, look, we represent the buyer as the buyer's agent. And the bottom box is checked for seller. Lots and lots of different boxes, folks, but it all changes depending on who you represent and who is filling out the form. Again, you have to lock this form in because it's going to edit other pages. So print to a PDF and save that. And then I'm going to show you the consent form. This is the unrepresented compensation consent form. I didn't fill in the rest of this, but basically you are going to ask for what you're going to be paid under that compensation section and print to a PDF and save that as well, just to make sure it's not linking with anything else that you're working on, like your purchase contract, okay? Just lock those down, save them, and then you can, well, that one you have to take to get signature anyway. Typically, you're not doing that away from the seller. All right. So here's the bottom of the unrepresented seller. Again, you've got to, oh, this is the purchase contract. You've got to put down at the bottom, unrepresented, and again, no box is checked on 464 here. Of course, it doesn't have buyer only, but you still wouldn't want to check it. And why are you not checking a box there? The other one was line 450. This is 464. It says agency confirmation. It says broker named in section 9A above is the agent of. Who's listed in 9A? Who's listed in 9A? No one. So you can't have a box checked because there is no broker named. So if you check a box in 464 or the one above on line 450 for buyer, there is no broker, so you cannot check a box. This is probably one of the reasons this is most often checked, because they're like, well, I'm not representing them. That must be the other box. I'll check the other box. Read the line. There is nobody there. So you can't check a box because there is nobody that's the agent of, right? Because there is no broker. All right. Number 3, dual agency and limited representation. This always gets confusing for folks. We have several different things. There are 3 forms of agency that must be addressed when you're dealing with dual and limited representation. We've technically gone over some of them, but we'll just make sure we're going over all of them here. Number 1 is the ready form, right? We just talked about that. Page 10 of the purchase contract. We just went over those, right? And then the limited representation form. So I use the word dual only when it's one agent representing both sides, okay? I say limited when it's Realty One Group umbrella. Could be 2 agents on the same team, could be 2 agents in the same office, could be agents in one of our 8 offices, or 2 agents in our 8 offices here, okay? So let's see what's going to come up first. One is, we're going back to the ready form. Obviously, it depends on where you are here, but you have to check the boxes that apply. I'm not going to go over each one. So second is the bottom of the contract. Here you have the choice on line 450. This is on the purchase contract. This is under the buyer section, right? Broker above is the agent of. In this scenario, if you have this preset in your forms as a template, make sure you go and switch your boxes and check the boxes as both buyer and seller. If Realty One Group is in the top in 8 and in 9, you have to check both buyer and seller, both on the top of 8R and on 9B. See, both buyer and seller, both buyer and seller. Those are the boxes for dual or limited representation that have to be checked. And if you don't do this, you're going to get flagged and have to fix it. Because you can't say we represent only one side when we actually represent both sides. Okay? So then the last form is the limited representation form, right? Here you have either one licensee, again, what I refer to as dual, or 2 licensees. The first line is who's representing the buyer. The second line is who's representing the seller. Now, many of you are on teams. The team may have, the team lead is on every listing. But if in fact that seller was working with somebody else on the team, and the team lead isn't the one that's actually dealt with them, we may end up seeing the team lead represent the buyer, even though they're listed on the listing. The seller will have some other agent name. That's okay. We're defining it and making sure that we're showing clearly who is representing each side on this document that both parties sign, right? When should you present consent to limited representation? When does it apply and when do you present it to your client? It's a quiet group today. Any?
If it's consent to both the buyer and the seller, I would think you present it at the time that you do the initial paperwork.
When you do the initial paperwork, or how about when you write the offer?
Yeah.
So when you write the offer, you have to present that. And when should it be presented? At the end of the contract? After you've gone after the whole purchase contract, and then you go, oh, by the way, could you sign this? But before? Why before? Why?
Because you gotta understand who's representing him or her on that side.
And How about the fact that you are limited in what you now can communicate? And they need to know that as you're going through that purchase contract. Now, I'll tell you a little trick that I used to do. First time I ever went out with buyers, I talk about market conditions. I talk about what's going on with concessions. Are sellers giving concessions? Are buyers getting concessions? What type of concessions are they getting? Because guess what? If I end up in a limited representation, I can no longer have that conversation. But guess what? I've already had the
Okay, prior
conversation.
to the fact.
I'm not in a limited representation situation at that point. I'm doing my job telling my buyer that my value is here. I'm making sure they understand everything that's going on in the market. And by the way, if in fact we end up in a limited representation situation, I'll have to ask you what you want to offer on that property. And you're going to have to tell me if you want any concessions and what type of concessions you want, because I won't be able to ask. Oh, isn't that great? When we get now here, we need you to sign this limited representation. Do you remember we were talking about that when we went out on the first day we were out? Oh yeah, you remember. Awesome. That's great. I'm glad you remember those conversations. So this is the form we talked about. This covers that limited representation. Now then, we're going to go to the purchase contract. What did you want to offer? Okay, great. And then we're on page 2. And oh, look, it says concessions. Were there concessions? I need to fill in the line. What did you want? Oh, you wanted to ask for buyer closing costs. Okay, how much did you want to ask for buyer closing costs? Because that's all I can say at that point.
Have you had clients refuse to see?
No,
Okay.
no.
Neither buyers nor sellers.
No.
Yeah.
The question for those online was, have I had clients that have refused to see Realty One Group properties because of the limited representation? The answer is no. And I think partially if you talk to your client about what the potential issues could be, you address that situation. So you don't have to worry about it as you get to it, right? So it's a matter of education. You just need to educate your clients, right? And sellers often think, well, cool, I can save money. Well, you can. You have to have that conversation with your seller. If that's their goal, they want to save money, then you have to talk about the pros and cons. Again, do they want you to be a limited, a dual agent where you're actually representing both sides? Because that 9 times out of 10, I tell my sellers, I do not want to be a dual agent. And the few times I've had people at open houses that come through and want to write an offer and want me to write the offer for them, I've said, I'll do it as you're unlimited, unrepresented, fine. But most of those times they've been close friends of mine. I'm like, I can't do dual representation at this point. I just can't. I have too much of a relationship with that seller that I wouldn't be able to adequately do that. Now, but I can refer you to somebody else if you'd like to talk to another agent, right? So there are options there. But here, this is what you need to do. And again, I recommend, as we're talking about promoting your value, this is part of what you need to be including early on so that you are sharing your value and what you're giving your client.
Why are you so limited? Like market conditions and the price, why is it so limited?
A great question. Why is it so limiting in terms of what you can communicate? Number one is you do not want to end up in implied agency. Okay. But number two is you can do no harm to the other party because Realty One Group is the umbrella here. It's like you can't hurt your brother or your sister, right? You're not allowed to harm.
To more than one person.
Well, you can't be
Yeah.
fiduciary to more than one person, but it's the harm that's the reason you're limited, right? You can't say, oh my gosh, the price on this just sucks. I don't know what that agent was thinking. You can't do that, right? At that point, you just have to keep your mouth shut. Can you even provide comps? There's questions on whether you can provide comps under a limited representation. So we'll get some more. There are different takes on that, right? Because if in your comps, you're saying that it's priced wrong.
Yeah, and I get like the pricing.
It depends on where you get the comp from, because if you do it through the I forget the name of the program that we have.
RPR.
Yeah, then they're saying, not you. You're just showing them what it's.
If you're not modifying anything,
Right.
right? But RPR is just like any other algorithm. It's intended for you to modify those listings. When you're doing RPR, I hope you guys are not just using what it gives you, because
No.
if you go through and look at those,
Yeah. you have
they
to-
need to be worked through, right? So technically, you should not be modifying those things. So if you're giving comps, can you just give the list of the comps? Yes.
And
Right.
And the market conditions, that's not broad enough. Usually mentioned you also can't give like insights into concessions, generally speaking.
No, because you're
That's what
harming,
we want.
you're harming the seller. If you tell your buyer, hey, why don't you ask for 3% in concessions? That's harming the seller.
Well, I mean, but more as like matter of fact, if you pull like the data, like the comp, here's just a list of the comps, here are the conditions that are in those comps.
The concessions in
concessions,
those
I mean,
comps,
yeah.
well, that's fine. But you
Okay.
can't say, hey, why don't you ask for 3% in
It should be
concessions?
inside, Yeah.
It's up to the buyer to say they want something, and even like an unrepresented seller, that and a little different, but unrepresented seller, you just have to say, what do you want? Tell me how to fill in the blanks for an unrepresented seller. So not quite as harsh for a limited, but you have to be very careful, because again, you can't harm the other party. I really hope I'm recording this and put that back on record. If I didn't, I'll have fun doing this again. All right, number 4, we got to move on because we're halfway through in time and not halfway through in 15 items. Dual agency, when is it not allowed? Does anybody know this? When can you not do dual agency? Any guesses?
If you're related or something, like family, spouse.
How about if you are the owner of the property? You cannot represent the buyer. What is the number one reason why you can't represent the buyer? Does anybody know that one? There's a very clear-cut reason
Say the question again?
why, if you're the owner of the property, what is the number one reason why you cannot represent the buyer?
Well, for one, it'd be a conflict of interest.
It would be a conflict of interest, and who does not cover you if you do that?
You're broke.
E&O.
Yeah.
Your E&O insurance will not cover you if you are the owner of the property. You brought up the other one. You're related to the owner of the property. You can't represent somebody else and go, yeah, it's my mom selling it. Let me represent you. It's fine. No problem. Yeah, you can't do that. Sorry. Not allowed. Okay. And it is not dual agency or limited if it is Realty One Group with a franchise as the cross broker. Why is that? Does anybody know? Because in our state, we do have franchise Realty One Group offices. I hope you realize that, right? In Tucson, Flagstaff, Payson, Prescott, Lake Havasu, and you guys can do business out there, right? But if you have a Realty One Group that is a part of Mountain Desert Integrity, that's not limited representation. They are not under who?
The same DB.
The same designated broker. In Arizona, our corporate offices are under Ron Kopis. He is our designated broker. These other ones have their own designated broker, okay? And by the way, there are like, I think there are like 6 Mountain Desert offices, so they are all over the place. Integrity, that's in Tucson. I don't know if it's anywhere else. Mountain Desert is like all over the state, so. All right, number 5. Lead-based paint disclosure. All right, we're going to go through this quickly and we'll see how many people fall on the floor here. Lead-based paint disclosure, if prior to what date? So if the home was built in 1978, do you need the lead-based paint disclosure?
Yes,
Yes, still.
What is
Yes.
that word?
If
yes.
it's prior to, then no.
It's prior to. So 1978 is not prior to. So it's 1977 or before. Prior to is after.
Before.
Prior to is before. 1978 is not included in prior to. So number 1, please learn the dates. I've had people ask for it in 1980 and I'm like, I just don't even get that one, but okay. All right.
I had
So-
a broker have me fill that out as 1978 was still liable.
Built before 1970.
It was the first year, it was not, yeah, it's okay.
Cannot be.
It says built before 1978. I would just Send that back to him. The other says if premises were constructed in 1978 or later. It's very clear, but people can't seem to read it. All right, two things here. Actually, the issue is not the check boxes on the left. That is not what the number one issue is. Although please understand you have two options. If you did not get this form in the MLS listing, or it was sent to you prior to writing your contract, which box do you check up above? If you did not get the lead-based paint information, did not, what box do you check?
The second one.
175.
Line 175, seller
175.
should provide lead-based paint. So if you don't have the lead-based paint form, that's fine. Just check that box and move on. You don't need to panic, but check a box, right? Normally, no lead-based paint, you don't check any boxes. But here's where the big problem is. Guess what? Our signature programs autofill both lines 181 and 182 with initials, both lines. Can both lines be signed?
Nope.
No. So you must select one line to initial, which means you as the agent needs to remove the other initials. You've got to literally click on them and hit a trash can and get it out of there. Because otherwise, guess what? You get flagged and you get to fix this form. Lots of fun. We get to fix this form all the time. Now, there are more issues with this form. So, oh, I can't see my thing. So we're going to try to move this up here. 2 steps. Seller landlord discloses information. Can somebody count how many boxes are there? I have them written over to the side. How many things that are there? 2 check boxes, 3 initials, and then 1 signature and date on the form. A seller has to do all of those steps. They've got A, B, and then C. C doesn't have a box, but C has initials, okay? So A and B have check boxes. You have to check one or the other, not you. Client has to check one or the other. Then they need to initial, okay? Then the listing agent gets to initial and sign. We'll look at the bottom here in just a second. See the bottom? Seller, listing agent, seller, date, right? Does the listing agent need to initial? If so, where? Okay, line 39, listing agent must initial. Then the buyer gets to review and acknowledge. They have 1 checkbox, 3 initials, 1 signature and date. They need to check if they have received a 10-day opportunity or waived the opportunity. They must initial on all 3 sections, A, B, and C. Then they need to sign and date. The buyer's agent then needs to sign as the cooperating agent and cooperating agent's signature, initial and sign. So a selling agent, 1 initial, 1 signature. The reason this is important, I get people that tell me, oh, they're so frustrated. They don't want to have to go back and fix their lead-based paint. What entity oversees the lead-based paint disclosure? Does anybody know? Federal government. What part of the federal government oversees this? The EPA. Thank you. Good job. All right. And can you do the lead-based paint in counterpart? Meaning one party signs one document and the other party signs another document. Title is saying no. They are correct. You cannot do it. It is the only document in our stack that you cannot do in counterpart. Why is that? We don't make that rule. Who makes that rule? The EPA. Can the buyer fill in their part before the seller?
I would think no. How do they fill in their part if they don't have?
No.
Nothing to
Why?
interpret. It's fine.
So it says the buyer must complete this and initial, right? A, B, and C. The first line says, buyer has read the information set forth above and has received copies of the reports, records, or other materials listed above, if any. If they fill that in and the section above has not been completed, what did they read? And again, I don't care if you do this form wrong, but I will pick up the phone and call you and ask you, who is responsible for making sure a seller complies with the EPA document? The agent is responsible, okay? This is the only document in our contract that comes with a potential fine. Does anybody have a guess on the amount those fines can be?
It's a lot.
It's a lot. Any guesses?
Tell us more.
Well, if a licensee fails, this is if a licensee fails to give a buyer the pamphlet and disclosures, they can face penalties, which can range from 10 to 30,000 per violation. Remember that thing earlier where I had you count the numbers that I had up there? So as the agent representing the seller, there are 6 spots the seller would have put their stuff and your 2 spots. That's 8 violations for you. If you're on the buyer side, count all of those 8 violations plus all of your buyer violations, because you allowed your buyer to sign an initial before the seller did anything. So who would like to multiply that times $10,000?
It's a lot.
It's a lot. And guess what? It's not me. It has nothing to do with Realty One Group, has nothing to do with the Arizona Department of Real Estate. So when we call you and say, please fix your lead-based paint disclosure, just trying to take care of you. So it's your choice. And I've had agents say, yeah, I can't reach them. I don't want to deal with that. I'm like, that's fine. Please Google. This was from Google last night, folks. And one of these is dated September of 2023. These are not 1990, 1978. There are fines that have been assessed as of 2024.
It'd be higher now.
It could be that was, yeah, it went to 30,000 in 2023.
Those are fines to the sellers,
Those are fines to the agents.
to the agents, both.
Either
sides.
one, depending on the errors done, they can assess that. And they can assess that if they choose to come and pull our files. And they pull the files and decide something's been done wrong, they're gonna call the agent. So, and that's why we work so hard to make sure you do that right. So the lease requires lead-based paint disclosures as well. Who's doing leases with properties prior to 1978? I was. I've certainly put tenants in properties prior to that. Did you know that there is a separate document for that? So there is a different lead-based paint form for leases that actually says landlord on it, right? It says rentals. Please pull the right document. It actually says landlord disclosure because the landlord is obligated to disclose that information. And guess who's responsible for that again? The agents, not me, you, sorry, not me. Okay, so please make sure you do that. All right, we are running out of time. Buyer contingency addendum. Number 6, processing issue, buyer contingency. All right, this is the first document I've ever seen that actually has the words instructions on it. If buyer has accepted an offer to purchase buyer's property, mark the box on line 10 and complete only sections 1 and 3. If buyer has not accepted an offer, or by the way, has not been listed yet, right? Because they can't accept an offer if they haven't been listed. So either applies. To purchase their property, mark the box on line 18 and complete only sections 2 and 3. This is a brand new form from July of 2023. Please make sure you're using the right form. But you need to look at that. Section 1, contingent upon closing of buyer's property, right? There is a date in here. You need to put the does not close by a date. You've got to put a date there. All right. Because this says, or this contract shall be deemed canceled and earnest money shall be released to buyer. If you don't have a date there, how do we know when that applies? Right? You've got to have a date there. And then the buyer and sellers have to initial. Okay. This is actually not the part that she was saying was the issue in terms of what people do wrong here. And I can attest to this because I've had 3 people call me on this same issue. Not this page, but again, section 2, if it hasn't been listed yet, you've got to fill out all these things. And the buyer and sellers have to initial. But, excuse me, the area that is the main issue on this brand new version of the buyer contingency is they have slipped in these 2 boxes on line 63 and 65, and everybody seems to ignore them. But they're really critical because they tell you when the buyer's timeline begins counting. How do you know how long when the inspection period ends if you don't know when it begins? Right? So 63 says the date that the contract is signed and any incorporated counteroffer is delivered to and received by the appropriate broker indicated in section 8I, meaning the selling broker. So if you already have a contract, if the buyer already has a contract on their property and they have written this offer, then they need to start the timeline. You need to check, the buyer needs to check this box. This is coming from the buyer, right? The buyer needs to check this box that the timeline begins right now, okay? If you don't have an offer yet on your property as the buyer, you don't want usually to start that. You can, if you want to, if you know your property is going to sell quickly and you actually want to do your inspection first, the buyer has the option to start their timeline immediately, okay? Or they can wait for 3 days after they have sent on their accepted contract and sent it to the seller for review. In this new contract, in this new contingency, the seller actually has the opportunity in those 3 days to cancel the whole deal, which is why it doesn't start immediately upon receipt of that, because the seller could be canceling it. Why would you do an inspection if the seller's like, yeah, nope, done, see ya, sorry, not moving forward with you, okay? So you just need to know those two things are there. One of those two boxes need to be checked. Three files in the last week have not had those boxes checked. I'm like, oh, when did the buyer's timeline start? I don't know. Got a problem. You guys got to fix that. Okay. Number 7, listing agreement. Again, we're just going over things that are issues here. The number 1 issue with the listing agreement is, guess what? Well, not the retainer, although I'm expecting we'll start seeing people use the retainer. So I threw that in there, but the reason the listing agreement page 2 comes up is, guess what? What do you put on line 39? If you are the listing agent, what is going on line 39? Pick either side of that. I don't care. What number are you putting on that line? What does line 38 say? Just 38. Somebody read that out loud to me. Total commission. Oh my gosh. A total commission, right? And then they put on line 39, I don't know, let's say 2%. And then they put on line 42, 2%. Guess what you're making as the listing agent?
2%.
No, you're making 0.
Oh, yeah, because you owe the 2%.
Because you owe the 2%.
Go.
You owe the 2% and you're only getting 2%. So congratulations for doing all this work for nothing. And guess what? We can't change that. That's on you. We can just let you know, are you sure that's what you meant to do? Because by the way, you pay us a transaction fee that's going to come out of your pocket now. So might want to think about that next time before you write your listing contract. Or go back to the seller and say, I made a little mistake. Can we fix this, please? This is not what we discussed. I kind of put the wrong number on line 39. Does that make sense? Really, really, really important. Happens all the time, right? This is your job. This is your pocket, and it's going to come out of your pocket. A lot of it. So don't do that.
Is that changing? Is that the new one? Or is that gonna change with all
I don't expect that part of the ER to change because they're still going to allow compensation from the seller.
Mhm.
So I don't expect that part of it to change. There may be something else there that changes. Oh, favorite issue. What do you guys think this is going to be? What do you think the contract pricing issue with closing date is going to be? Any guess? Oh, da, 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 da. On or before. So not sure when to close, no problem. Just put on or before, right? No, don't do that. Please don't do that. And why do we not do that? So here are the facts. Buyer and seller entered into contract with the close of escrow on April 27th. Language written in the additional terms and conditions states close of escrow to be on or before April 27th. On April 24th, the buyer notified seller that his loan was ready, so he wanted to close escrow on April 25th. Seller says he can't close on the 25th because his moving company isn't coming to move his items until the 26th. So can the buyer demand the seller close on April 25th? Said on or before. Like, right?
the
Everybody
contract.
agreed. Go ahead.
Yeah, because you put it in the contract.
But what does honor before really mean? Right?
Whatever they want it to mean.
Ah, there you go. The only agreed upon closing date is April 27th, unless there's a meeting of minds to move the date. The agreed upon closing date remains April 27th. So here's the challenge, right? You are creating something that is perceived as ambiguous and often creates confusion and differing expectations. And we have our title person here. We don't have a lender here today, but title, what happens in your office if you see honor before? What date are you using to set everything up?
I'm using the contract date, the original date, because I don't know when or before is.
She doesn't know when or before is, right? So she has to use that date. If you guys don't understand that the lender and title people have to have a date that is the end goal, and they have to back up from that, and they have to process things. The lender has a closing department, has people that do docs. They have all these people that have to do work prior to that close of escrow date. If somebody's randomly going, yeah, you know what, we think we're going to close on the 19th, but we told everybody the 27th. Everybody's working off the 27th. So when you do honor before, it's ambiguous to everybody, and just set the date. And if you can move it up and everybody is able to move it up, great, do an addendum, right? Please do not put honor before. It will be flagged in our offices because it does create that confusion and ambiguity. And I love this is from an attorney. This was, I think, Scott Drucker's comment. This is like 15 years ago. He wrote this. And he used the phrase differing expectations. You guys have heard me say, set your expectations for your clients. This is one of those times you are thoroughly confusing everybody and you're not setting expectations, because is your buyer supposed to set the moving trucks up for a week early? On the day of, when are they supposed to do that? So please don't use that language.
Can I throw a couple of things in?
Yep.
One, I heard that from another broker that a contract must have an end date, and when you write it on or before, it does not have an end date.
Correct.
The other thing is in escrow, when we, like you said, we take a date and move backwards, we want to order a seller's payoff statement in the month it's closing. So if a contract's written on or before the 19th, we're waiting until like the 5th or 6th to make sure that payment's been made. If you then move it up to the 3rd, there's mortgage companies out there that can take as long as 10 days to get a payoff statement. So now we are the ones holding it up because
Oh my
the
gosh.
date's been moved up.
Thank you.
Actually, interest each day changes.
Exactly.
So which day is closing,
Correct. So all your calculations change with that change of close of escrow date. Okay. In Arizona, I have agents that have come from other states, and I understand your states cross out, add text, check boxes after a contract's been signed. In Arizona, we do not do that. Please, please, please use a counteroffer or an addendum to make changes to the contract. So if you missed one of those boxes we talked about, we want an addendum to say line 151 box shall be checked, or whatever it is, right? To reference back to where in the contract it is. Now, I have had some folks that have, let's see, I'll come back to that in just a second. Pre-qual and LSU. It's funny if we take our time to actually read what the documents actually state. I know you guys get upset when we ask for these to be signed. I don't know if you've ever read actually what it says just above the buyer's signature. It says buyer acknowledges receipt of copy hereof and grants permission to broker to submit this pre-qualification form with a contract. So if the buyer has not signed that, you actually don't have permission to send it. Okay, so you may get upset with us that we're asking for the pre-qualification form, but there is a reason to be signed. There is a reason we're asking for that. Those are specific instructions on the form, right? It's not a broker issue or Department of Real Estate issue. It's an issue of you can't share that data without that buyer signing that. So please work to get the pre-qual signed. Now, why would we care what whether the LSU is signed, right? The contract says we get an LSU. Again, it says the buyer has instructed and lender agrees to provide. So is the lender a party to this contract? The lender is? Really? Where's the lender on the contract?
Not this contract.
The lender is not a part of our contract. The contract's between buyer and seller, okay? So by the buyer signing this, they are tying their lender in because this loan status update is signed by the lender. And the lender then agrees to provide this within 10 days, right? So please get at least one of these signed so that we have that in our file. All right, number 11 is adding or changing a buyer. I can't tell you how many times agents have said to me in the last 10 months, oh yeah, the lender just said we needed to add the mom or the dad or the brother or so-and-so. It's not a big deal. We just added their name on an addendum. Oh, okay, no problem. Just put their name on the addendum. That's fine. Go ahead and write their name, right? Buyer and seller agree. Danielle Thomas is added as a second buyer. Who cares, right? That's great. Contract was written on 4/2, closings on April 25th. We're good, right? All other terms and conditions remain the same. Well, there is just a little problem here. What happens if Danielle doesn't like the work that was done on the kitchen that was a repair, right? Whoever you're adding has to accept the contract to where you are in the process. Great, if you're not through the inspection period, fine. But 9 times out of 10, these buyers are added in the last 6 days prior to closing, okay? And they have to receive all copies of the contract. So instead, let's say something like Danielle Thomas is being added as a second buyer in this contract. By signing below, she acknowledges that she has received a copy of all contract documents and agrees to all contract terms, conditions, and contingencies that have been satisfied or removed and approves the condition of the premises. Then seller and brokers are relieved of all liability regarding the same, right? We're adding somebody there. You're putting yourself and our brokerage at risk if this person hasn't even seen the contract. Now, I get all the time, oh, it's the mother. They've been involved the whole time. They got copies of it. Really? Do you know that for a fact? And are they agreeing to all of that? Where did I didn't see that signed anywhere. Really? Did you know that? I didn't know that. And if you go to a court, what is the judge going to say? Where's the proof? They got what? How do you know they got it? Well, but they were on all of our conversations, really? Great. Do verbal have anything to do with our written contracts or resale contracts in the state of Arizona? Has to be in what? Writing. Please, please, please. I will keep this and send this out to people. I came up with that last night.
The other thing is if Danielle's married and her husband's not going.
Ah.
We have to have a disclaimer and he has to agree to sign that disclaimer.
That is very true. So, yes, you do have to get a disclaimer if that other party is married, and the other person is not going on there. So there are lots of different things that are involved in there. Now, we've got a few minutes left here. Outdated forms, please, please, if any of you download forms and put them onto your computer to use from your computer, please take a few minutes right now. Go look to make sure you're using the latest version of the forms. We do know there will be new forms coming. We know this. I expect that they will come up in the next few months, but go to SkySlope Forms. If you use SkySlope Forms, make sure you have the latest versions. Transaction Desk, the same. These are the forms from AAR. That's where we can get those sets of forms. SkySlope working documents, that is different than SkySlope Forms. Those are the Realty One Group version of our forms that we ask you to use. You should be looking for the new affiliated business arrangement form. That is brand new, does not have an address on it. Please, if you're using the outdated one with an address, we worked very hard to get that removed. So use the new form. And then the last one, you can go to AAR online if you are sharing copies of forms. This is critically important. If you are sharing with anyone copies of our forms, they need to have the word sample written across them. Please, please do not email blank forms to anyone right now. Okay, they are copyrighted forms. No one else has the right to use our forms except for licensed real estate professionals. All right, actually realtors, because they come from AAR. All right, number 13, incomplete forms. Biggest issues with incomplete forms, guess what? It's missing text on lines where there must be text written, and it's missing that text. Missing pages or flipped pages. Please, before you scan stuff, make sure you've got them all upright and in the same direction when you scan it in. The reason for this is if you're using a signature program, you can't sign upside down, so that's a problem. But we need it in our system so we can see it. And I don't know how many people realize, but on the bottom of forms, we have the broker signs off on them, including Cherie. So she signs off as the broker reviewing them for us. And if there's no bottom of the page, if the bottom of the page is at the top, she can't sign off on that. She's got to take it out, sort it around, put it back in. Not signed, pages that we get that are not signed. Please make sure we've got signatures and dates. And I would go on and even say times. Many of the contract documents, actually, did I pull them here? Counteroffer, right? Guess what? That has a time on there. There is a reason there's a timestamp, okay? So if there's a timestamp there, please put the time there. If you don't know how to find the time on your SkySlope Forms DigiSign or on Transaction Desk AuthentiSign, if you click on the signature, it will open up some options below and you can click the tab for the times to be added. Multiple counteroffer forms. This is crazy. You do have dates and times, and it's critical because things may be going back and forth on the same day on multiple counters. So please make sure you're adding the times and dates on all of these. Look, see how many of you knew there were all of these that had times on there. 14, incorrect use of forms. Addendum versus a notice. Does anybody know what the difference between those two documents are?
That needs to be signed, the other one's just a one-way flow.
Who needs to sign the addendum?
Buyer and seller.
Both buyer and seller. Who needs to sign a notice?
The one that's giving the notice.
The one that's giving the notice. So here is an addendum and here's the signature. Oops. What the number was for there. That's weird. Something happened with my, don't know what the number went to. Okay. So here is your signature blocks, right? It's either buyer, seller, landlord, tenant, addendum. You have two parties to this. The notice, this is the listing contract addendum. So there's two different addendums. You have a regular addendum, listing contract addendum. If you are doing a listing, please do not use an addendum. Use the listing contract addendum because it's between an owner and a broker, not a buyer and a seller. So you really need to make sure you're using the right addendum. We often get the regular addendum being used for correcting a listing contract. There's no buyer involved. So we don't know where they're signing because they're not a party to the contract. So you need owner and agent or broker and owner on there. Then the notice form, notice disclosure has one signature line. And we don't know which party it is, so you just put the name of the party underneath. So what would be something that would be a notice?
They haven't met a deadline. And the other party.
That would be a cure notice.
Yeah.
That would be a cure notice, but what would you use a regular notice for? Title? Guesses?
I have seen it on unfulfilled loan contingency.
An unfulfilled loan contingent. Oh, yes. So if, well, no, I think there's another form for that. I think there's another form for that. But notice, let's say something changes in the seller property disclosure statement now. Let's say the water heater breaks. Okay. You need to notify the buyer that the water heater broke and what you did to it. But there is no place for the other party to say, got your information. It's just notice being delivered. Now, what does that give the buyer the opportunity to do? If the seller issues a notice that the water heater broke,
Cancel the deal. They can back out.
how many days do they have to cancel?
3.
That would be my guess, but it would be a guess.
It would be a wrong guess.
What would it be?
5 days.
5 days.
Yeah, I was just going off the spot. Yeah, typically 5.
Okay, Spuds is 5 as well. The only thing in the Spuds that's 3 days is the days prior to close of escrow that work has to be done. The Spuds have to be delivered in 3 days.
Yeah.
Okay,
And
sorry,
it's
sorry.
5 physical days, not 5 business days.
It's 5 days.
Okay.
Real estate timeline is days, not business days. People may write that in, but the contract says 5 days.
Okay.
So that's one of the areas. There are other things that you might notify, and you're just making a notification. You would use the notice and disclosure form. Okay, addendum. So here again, the addendum has that. I don't know why that came up last. Last item is checklist type. This is on our systems, on our SkySlope systems. Guess what? When you do your SkySlope and put this in here, we actually have a whole series of checklist types for when you initially set it up. If you're the seller, it's a traditional listing, then you're converting it to a sold listing, but you don't represent the buyer. You go to residential, traditional listing, sold, right? So we have all of these worked out. They make a difference because it changes what your checklist is of the documents that are needed on your file, and it changes whether or not you're paying 1 or 2 sides of your transaction fees, right? Transaction fees are per side. So if you are doing both sides, you are a dual agent, you will have 2 processing fees. Okay, please understand that. All right, let's see. We just went through all of that and I made it.
Wow.
Sorry, guys, that was a lot to cover. I was looking at that last night going, there are a lot of different issues that come up on our files. All right, so any questions? I just hope I recorded this. I don't know if I did.
You'll know soon.
I will know soon. Oh, look, now I can get that to go away. Anybody online have any questions?
No, thank you. It was great.
No questions.
Oh my gosh, I made everybody just get quiet there. Anybody here have any questions coming back to that? Yes.
So for limited agency, so the way you would notify your client that you are in a limited agency is just by telling them, hey, you're about to sign something that says that I'm gonna be limited as an agent for 2 because Realty One is under both the seller and the buyer, that one. Or because
I think you're gonna have that conversation when you first meet with your client. And here, let me take this out of here. And I have a feeling I did not record that. That is gonna be hysterically funny if I really did not.
Not really.
No, it's recording. It says stop video. Oh, no, that's not. I don't think I did. It doesn't say it, does it?
No.
I did not record that. Really? I'll have to do that again. That'll be fun. Okay. Did I really not?
Melissa,
Yeah.
it says it's recording on my online. It says it's
Good.
a,
Oh, there it is.
yeah.
It is.
Ah, there you go.
Yay. Thank you. So really what you're gonna do is, the question is, when would you bring up the limited agency? It really is when you first meet with your client, whether it is a seller or a buyer, you're gonna have a conversation about agency. I mean, you're gonna go back, the reason I did this was to go back to an agency form, right? So let me see if I can pull this up. We all the way to the top. So, right, so if you are actually, can you guys see that? It's just not as big, right? Can you guys online see that?
Yeah, we can still see. It's
Okay.
Yes.
nice.
All right. I guess I'm just not in the slideshow. There you go. So the slideshow did not Okay, there, that's fine. So you're gonna have a conversation with your client about being a buyer representative or a seller representative or limited agency, right? And this talks about the fact, and it says on the bottom, buyer consents to the limited if in the case that the broker shall act as both, then the buyer or the seller consents to this limited representation. In the event of that, there will be additional materials provided, but you can talk about the fact that you can do no harm to the other party, right? Because you're all under the umbrella of Realty One Group. So if that conversation is done in advance, and again, that's where then I slide in and talk about what are buyers getting these days, right? And even to the seller as well. By the way, buyers are asking for these things. Please be aware of that, right? And because if all of a sudden a buyer from Realty One Group comes in and offers my seller and says, or asks my seller, hey, I want 3% in concessions, the seller says, no way in hell I'm paying any of this, da 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 da. At that point, I'm going to say, well, I need you to understand, forget this buyer. I need you to understand that people have been asking for that. That is not unusual. Remember when we looked at comps, I did show you that, right? Again, that's where if you're looking at the comps, and to your point, there were seller concessions on 7 of the 8 comps we looked at. Remember, we talked about the concessions and what might have been included. Oh yeah, okay, right? But you can't do harm to the other party. So you can't say, well, then just don't accept that, right? I mean, you have to be very careful on what your language is and not creating implied agency. So you can't, to the other party, make them feel like you are representing their fiduciary interest, because you're not. And that's the unrepresented seller part or unrepresented buyer part, right? If you have an unrepresented buyer, you do have to be very careful on, implied agency. And in fact, making sure they understand, please do not tell me your financial situation. Like, I don't want to know your financial situation. Send me your pre-qual. That's all I need. Right? You don't want somebody to go, oh yeah, I just want $1 million and I'm going to buy this home, but I only want to spend, a quarter of the price. Like, okay, I know you have $1 million. My fiduciary is to the seller, not to you. Right? Does that make sense?
Yeah.
When you kind of different scenarios, it's like, wait a minute. Okay, who do you have fiduciary to? So
Are you seeing more of those right now?
unrepresented,
yeah,
yes, I've
yeah.
had to help agents over the last 2 weeks. And that's why, and I did a whole thing on how to do that. So I do have that whole thing set up specific for that, but on this was more that Cherie was talking about where the errors come in, what boxes don't get checked, right? So, just want to make sure, this was just really, there was so much. Cherie gave me top 10 and I was like, oh my gosh, I have a couple more. And I really wanted to go and cover the whole title, how you sign things, because that's a whole other issue. But I was like, we did an entire hour on signatures with the help of the title company. So if you have a buyer or seller in an LLC or a trust, or a representative, please go look at that saved recording, because it's titled that way and it goes over all those different options. And I'll tell you what, the one I just saw was the name of the seller was Melissa Schwartz of the Melissa Schwartz and, Sarah, Living Trust or whatever. And it was like, that's not the seller's name. That's your signature block. And they were using their signature block as the seller's name. Like, oh my gosh, you can't do that. Right? That's not the seller. The seller has to be either the entity, which is the trust, or the LLC, or the individual, but you can't have so-and-so of the, or as trustee of, like, oh, no, wrong. So please think about that when you're putting names in there, okay? I know
When was it recording?
it was recording. You'll be able to see it later. It's just not on Facebook. It'll go to YouTube later this week.
For the LLCs or trust?
Yes, that whole thing is on our YouTube channel.
Oh, okay.
Have a whole hour on that. Thanks to Roberta with Rock Title. She went over all of the different options for how you sign and different entities. It was really an amazing class. So I just didn't even include it. Okay, any last minute questions? Nope. Did you learn something?
I did.
All right. All right. Have a good one, folks. Have a great week. Oh, please reminder, Louise is, last day is Friday. Please come say goodbye to her. She'll be here. We're going to throw a little party from 4 to 5. And then if you want to see her, make sure you're here before 5, because I'm guessing at 5 o'clock, she will walk out that door. And then we do have a new office administrator. For those of you worried, I had a few emails from people. Yes, we've actually hired somebody. They will begin on Monday, and they've already been trained in the position and know it well. So we're very excited to welcome them back to the Realty One Group umbrella. But please say thanks to Louise, who's been with us for 12 years and been with between John Hall and Realty One Group for 28 years. It's crazy. So we really want to wish her well. And our commissioner will be here, and our deputy commissioner, because if you didn't know, that's where she's going. So thanks, Mandy.
And no flowers.
Another one, yeah, and no flowers. And then look for our one-day event. We've got some new information coming out tomorrow about what we're able to do at Heidi's Village. Come join us. We still have some t-shirts available. Let us know what your size is. We'll see if we've got one in your size. Have a good one. Thank you. All right.
Thank you, Melissa.
You are welcome. All right, let's